Testing, testing. 1, 2, 3. 1, 2, 3. Testing. Okay. Welcome, folks, to the Planning and Land Use Management Committee, Tuesday, June 18th. I'm joined by the Honorable Council Members Jose Huizar and Mitchell Englander. We do have a few items in the agenda today. On items 1 and 2, we can move on consent given there are no cards. Do we have a second on that? Are we good on items 1 and 2, colleagues? Okay. Let's move on items 1 and 2 on consent. We have items 3, 4, and 5, and I believe 4 and 5 are together. 6, the planning director is not here today, so we'll wait for his report, hopefully the next meeting. On item 3, we do have cards. So let's jump to item 3. We have staff come before the committee and gives a report on item 3.
Good afternoon, committee members. My name is Nick Hendricks, Department of City Planning. In its decision provided on November 27, 2012, the advisory agency granted in part a modification of vesting tentative tract map 69061 for a total of 707 units comprised of 312 senior apartment units and 395 market rate apartment units as requested, to be modified by the applicant to change the unit type from condominiums to apartments. In its decision also, the advisory agency denied their request to waive Quimby fees. So in our recommendation with regards to the appeal, it is still under the advisory agency's decision that the appeal be denied in part, and that the request by the applicant to have the option of both condominiums or apartments is satisfactory to us, but that the Quimby fees still be required as part of the project approval. And that basically concludes our recommendation.
Okay. We do have appellants on this item. Let's hear from the appellants. Good afternoon, sir.
Thank you, Mr. Chairman. Fred Gaines on behalf of the appellants in this case. This is a case where really an important policy of the city is being changed. It's being changed in the back of this particular property owner. In 2004, this is a project is approved for up to 879 units in 2 buildings. We now have a project that's already started construction for 707 units in 2 buildings, 395 in a building that's being constructed right now, and another building that can be up to 312 with this density bonus. It was all done by condo. The application was made for this modification because the project wanted to go forward as apartments. We wanted to clarify that it was going to be apartments, and frankly, to be charged the correct fee, the apartment fee, the dwelling unit construction tax that the city has. And what happened is the modification gets granted where, okay, you can't do condos, you can do apartments, but you're still going to pay the Quimby fee and not the apartment tax, which the city has charged for apartments for many, many decades. This is a decades-old precedent. It was very clear what happened in the city. Quimby, if you built condo, there's the Finn fee, God bless Howard Finn, that if it was a zone change and you built apartments, you paid that fee. And if you built by right apartments that were already, the density was already existing, then you pay the duct fee, the dwelling unit construction tax. And that's all that we want to do in this case. And literally, a case was decided a month before, the same month that we applied for this, where exactly the same thing happened. It had been a condo. They said they wanted to do apartments. They came back for a modification, and the decision of the planning was if you build the apartments, you pay the apartment fee. You don't pay the Quimby fee. So what happened in this case? Rec and Park wrote a letter when our modification was going through and said, hey, we want the Quimby fees. And to this day, if you go to the Rec and Park website, it says condos pay Quimby fees, apartments pay the apartment, the duct tax. But they wanted to get the Quimby fees. And they said the way it's been done is wrong. These decisions, and we've given into the record dozens of decisions by planning, and that they were all wrong when they said apartments pay the apartment tax. And they were not wrong. It makes sense even in terms of what we're talking about, because the word is required. That's the word in the law. If the map is required, then you pay the Quimby fee. So if you want to sell condo units or sell individual lots, you have to pay it. If the zone change is required to give you more density, you're doing a change in density, you're upping the density, you got to pay for that impact. That's why we pay that fee. But if you're building apartments to the allowed zoning, you already have the right to do that density. If you go to the counter, you pull the permit, and you get it, then you pay the duct tax. And in this case, the only thing that was going on was to get this project, this 9-year-old project, in the ground so that 200 employees could be out there today doing construction, is a deal was made that the 2 buildings will be on 2 separate lots. Didn't add 1 unit to what's going on. The nonsense here is that if we waited and built the 2 buildings and then split the lots so there were 2 ownerships, we don't pay the Quimby fee. But what we're being told now, and it's clearly a change of policy from all of the decisions that have occurred, is because you want to split it into 2 lots now, you're going to pay a Quimby fee for 700 units. Now, if my client had known this, instead of being handed the decision from a month ago that if it's going to be apartments, you're going to pay the apartment fee, he might have been able to wait even and build the buildings and split them and pay the duct tax and not the Quimby fee. But instead, he knew what the policy was. He knew the dozen decisions that had come down in the years before, and he went ahead and made the deal to get people out there working. And now he's saying 700 units, you're going to pay Quimby fee for every single one of them. That is why this, even if you want to change the policy, then have a hearing and change the policy. And tell everyone that this is what we're going to do. We're going to charge Quimby on all these cases.
Okay,
but you
Mr.
don't
Gaines.
do it on the back of this owner who relied in good faith and is out there doing this. This is a policy decision that you can make. Okay. And we ask you today to be fair, to treat us like everyone's been treated before, and to charge the appropriate fee, which is the duct tax on apartments and a Quimby fee if they're condos.
Thank you, sir.
Thank you, Mr. Chairman.
Thank you. Richard Weintraub?
Good afternoon.
Good afternoon.
Thank you both for listening today and taking the time to talk to us about this issue. I think that Fred covered most everything, and I know that you have a big hearing ahead of you. I just wanted to say that there were 2 things that were points that I want to bring home. The first is on this project, when we were selling it and we had to sell off a piece of it to our partners, we were really explicit with the planning department about the Quimby issue. Really, really explicit. And we were told absolutely under no conditions are you going to pay Quimby fees here. This is how we do it. This is how we've always done it. And as Fred said, even that very month, the exact same situation in Warner Center, took a condo lot, cut it into, and didn't have to pay the Quimby fees. The second thing I wanted to say is that, and had we not done that, then we would have gone a different route. But we've already started, and we're stuck today because of this. The other issue is I believe in parks. I believe in fees. I've paid a lot of Quimby fees before. This is not trying to be clever or cute and trying to get out of paying a fee so we could pay a lesser fee. I know exactly what these Quimby fees are for, and I don't think I know they don't apply in this case. So thank you very much for your time.
Thank you, Mr. Weintraub.
Thank you.
Representing the council office, Doug Metzman. Good afternoon, sir.
Afternoon, Mr. Chair, members of Plum. Doug Mensman speaking on behalf of Councilmember Dennis Zine. I just wanted to, I drafted a letter that Councilman signed that I believe you should have in your possession there, and just reiterating the support for the equal treatment, if you will. If the applicant were coming before you saying, I want to get waived from paying all fees on this, that would be a non-starter. Just the question is, willing to pay the dwelling unit construction tax. The applicant either has or is about to pay the actual Quimby on the two-lot split. So paying the appropriate fees for the appropriate product is really what we're looking for here. Just having this apartment building be treated the same way that every other apartment building has been. The other issue as part of the appeal that I think Mr. Gaines may have not touched on yet, or may eventually, is the question of changing the senior housing condition on lot 1, where the councilman does support either allowing an either-or modification of that condition, that if they go market rate, that it be market. If they opt to go for the density bonus, increasing the units there, that obviously the affordable units that would come with that, but that entire project then be conditioned as age-restricted housing.
Have they made it? Do you have an understanding of what is their objective? Have they told the council office what they want to do?
My understanding is that the applicant is interested in building a senior project, does want to build it, is having some difficulty assembling the financing and getting some backing on building that particular project. But I would let him speak to that if you want a little more clarity on that.
I'm just trying to get a better sense of what you were supporting.
Well, the councilman thinks that there is a definite need for senior housing in the city of LA. And when this project originally went through, liked the senior component. The original, I think, request was to get rid of the senior period. But the applicant, after meeting with the councilman, came back and said, look, even if you want to take advantage of the density bonus, then we want some of that. We want that to be senior housing for sure.
Have you had a conversation with the planning staff regarding the issue of fees? In your letter, my impression is that the councilman fully expects that the Quimby fees would be paid.
If they go condo, yes, had a conversation with the planning staff and had a conversation with the applicant, and the councilman feels that if they opt to build condominiums, for sure. If this project were to do a condo conversion in a few years, the councilman completely expects that Quimby fees be paid. But if the project's going to go forward pulling as an apartment permit, that the dwelling unit construction tax would be the fee that has been charged to other apartment permits that have been pulled.
Okay. Any questions from my colleagues, Councilman?
First and foremost, in reading all this, it doesn't appear that the applicant is trying to get out of fees. It appears from reading all the documents that the applicant's just trying to pay the appropriate fee.
It's my understanding as well.
And I know there's some significant difference in which fees apply, but it should be towards the appropriate project. And reading the councilman's letter, it says that he supports and defers, says, quote, I defer to the city attorney's office on interpreting whether this project would be subject to Quimby or not, or the dwelling unit construction tax. It's pretty clear to me, and crystal clear to me, that if they're apartments, then it should be the duck fee. But then if you refer to the summary of appeal, it actually says here market rate condominium or apartment units. So the question becomes, which one is it? We could, probably clear this up here and now,
right.
But the ambiguity is it says or, not. So which one is it?
And my intent is to ask the planning department to tell us what
ask
is in
staff.
front of us. So,
What
planning
is-
department coming up?
That's really the question I have. I think it's crystal clear. And while you're coming up, I also think it's critically important that we're consistent for developers once they have approvals. They've gone through a lot of the vetting process with the community, and it's too difficult for people to do business in the city if we keep flip-flopping and aren't consistent in what we should be applying in costs and fees. And so we have to have that consistency. And it's been consistent that if it's an apartment, we charge an apartment fee, and if it's a condo, we charge the Quimby fee. But if you can give us some clarity.
Yeah, can you tell us whether there was a flip-flopping or not? According to the applicant, they came in under one impression. They were given direction by planning staff. Then a letter came in from Rec and Parks. The scenario changed. Now we're in this predicament. So can you clarify exactly what happened and what is in front of us?
Well, what was originally approved, Nick Hendricks, City Planning, was condominiums. Due to the market changes, economic downturns, the applicant requested to modify that original decision
So let me
to
ask
go
you
to
this question.
apartments.
Let me ask you to pause for a second. when they applied for the condos initially, were they made aware of Quimby funds that were associated with that
Yes.
scenario? They were.
Yes.
Okay.
The Quimby funds are part of Section 1712C or Section 1712. Anything that's subdivided requires a Quimby fee payment. The code establishes that dwelling units that are created by a subdivision are subject to Quimby fees. It does not differentiate between apartments or condominiums. We understand that there's a huge difference between the amount and the amount that they would pay between a dwelling unit tax and a Quimby fee payment. But the code establishes that the zone, which establishes the amount of units that can be built on the site, that be subject to the Quimby fee.
Okay.
And dwelling units, as defined by the code, does not establish apartments or condominiums. It just establishes dwelling units anytime it's part of a subdivision. And that's what is before us, is the subdivision and the modification of what is being called a condo or an apartment. It's the judgment of the advisory agency and also the interpretation of the city attorney that Quimby fees do apply because of the way the code defines dwelling units. And that, there's always the option they can terminate the map and just do apartments if that's what they originally wanted to do, but that's not the case here. We granted them their ability to build apartments just by changing the technical language that's in the letter of determination, and that was only to remedy any technical conflicts that may come up when they're going through plan check, but that we never implied that we would waive the Quimby fees. The department has made mistakes in the past where Quimby fees were waived, but simply because the department made mistakes in the past does not mean we need to continue making the same mistake. So I believe that based on all of our research and communications with the city attorney's office, that our position is that they cannot be waived.
And therein lies the reason for the assertion that we're being inconsistent, because you're saying we made mistakes in the past where Quimby fees were not applied. And I guess they're familiar with that. And now we are asserting that interpretation of the law to assess the Quimby fee, which might be contradictory to other cases that they are aware of.
Yeah, we're trying to maintain consistency so that we don't have flip-flopping of determinations that waive them or do not waive them. I think it's important that we just follow the letter of the law and follow the spirit and intent of the law so that it's clear in every case in the future that Quimby fees aren't waived in subdivision cases.
And Doug, you want to come up? And you can stay there. The staff, you could stay there. Just hold on.
Hang on.
When you originally came to this case, were you aware that they were going to be assessed Quimby funds?
If there were condominiums, yes. I guess, I'm sorry, Doug Menzel speaking on behalf of Councilman Zine. I guess where the interpretation might be is in that as a result of the modification, the subdivision is for the Lot 1 and Lot 2 now. The units being built, if they're being built under department permit, aren't being created by the subdivision. The airspace units. They aren't individual airspace units. Apartment, they would be, dwelling units for sure, but as apartments, not as subdivided individual units.
Okay. But as such, because of this division, there is a scenario now where there's going to be condos and apartments? Are they all apartments or are they all condos? Do we know?
The Lot 2, which is currently under construction, is being constructed as apartment units and is being pulled, was pulled as an apartment. Lot 1, my understanding, and I'll defer to the applicant's representative for a little more clarity, is that they, as staff had recommended earlier, granting the appeal in part to be either apartment or condominiums, depending upon what they wanted to exercise, the condo as part of the map. And should they go condo, Quimby will be paid. No question. No objection. If they opt to go the apartment route, then they would not be, because essentially staff's interpretation is saying you pay Quimby either way, no matter how you build it, condo or apartments. And we're saying if they build condo, Quimby's fine and expected. If they go the route and pull and construct the units themselves under an apartment permit, not as subdivided airspace units, then the dwelling unit construction tax would be the one that should apply.
And that's what I'm hearing. And if we could just hear from the applicant's representative again, and for clarity on that. And is there a reason to leave in the flexibility? Is that necessary? Or just to lend some clarity that they will be apartments? It would give us, I think, that opportunity for clarity on what direction for what specific fee versus having the option when you can always exercise that option as a conversion later. If
The 395 that are under construction are apartments. They can be covenanted as apartments. There's no intention that there be condo. On the part that has not been built yet, we would like the ability to do condo. If we do it, we pay Quimby. This is not bizarre. This has happened over and over and over again in the history of the city. And if we do it as apartment, we would pay the apartment tax. It's not a bizarre situation at all. And I, the planning, fell on the sword and said they did it wrong. They didn't do it wrong. There's no units being created. The number of units here is the by right number of units. If we didn't apply for a map to divide it into 2 lots, we'd go over the counter and pull an apartment for apartment building, pay the apartment fee. So what they're saying is that splitting a big lot into 2 creates 707 Quimby units. That's what you're being asked to do here, and that's never been done before, and it doesn't even make any sense. If we were dividing into individual units to sell, then absolutely. And if we were changing the zone to get us to that number, absolutely. But when you already have that number, and the answer here was drop your map, build your buildings, and then split it, and you don't pay. We're going in circles.
In the interest of consistency, I would suggest that since there's an opportunity to collect the Quimby should they be exercised as condos, and if not, it's consistent with what has happened historically in the past, based on the documents as well. That the fact that these were already approved by right, a by right project, the only thing that triggered this question was the fact of the lot split. But in fact, that was from looking at all the math. It's actually a reduction in the number of units from the 879 you said to 707.
That's correct.
So it's actually even a reduction by
not
splitting
at the max.
By splitting the property. So with that, it would be my recommendation to allow the duct fee to be applied unless the condos are exercised, and then the Quimby would be collected on each door thereafter, if that were exercised. Based on what I'm hearing from staff, what's happened historically, and what the applicant is suggesting, and that way we retain that opportunity to collect the Quimby should that, and by what the council office is suggesting, that would be my suggestion to the chair.
So you want to deny the appeal?
To,
Or grant in part and deny in part?
yes.
By granting in part and denying in part, staff come on up. Does that allow you the flexibility to apply the appropriate fees based on how you're interpreting the law and based on city attorney's advice?
It is our, Nick Hendrick, City Planning, it is our understanding that in a subdivision scenario, we're unable to waive the Quimby fees, period. So our recommendation is that the Quimby fees be applied either way. The code does not differentiate between apartments or condos when it's a subdivision. And if the city attorney could opine on this, it would be helpful too.
City Attorney, we concur with that opinion. It's the way that the subdivision regulations in the code are written. So they just talk about subdivisions and they talk about dwelling units. They don't differentiate between condominiums and apartments. So here there's a subdivision, and so it triggers that requirement. And we did not find any ability in the code to waive that. So and overall, we're just trying to reach consistency here. So if you do want to fix that as a policy change, the best thing to do would be to amend the code so that from there on it's clear.
One question for the city attorney. In this particular project, did you look at the this project as it relates to that and in the way that it was originally 879, and the only thing that triggered it was the subdivision? And
Yeah,
in fact-
yes. We're aware of the history. It's just that the plain language of the code, it talks about a subdivision and it talks about dwelling units. So it doesn't really authorize the decision maker to waive the units for apartments.
Has the city done anything historically differently, as suggested by the applicant?
Well, we had limited time, but I talked to planning, and so my understanding has been that in the past, planning has done it both ways, which is mainly what we want to avoid here. We don't want to do it two different ways. We either want to exempt apartments or we want to charge them the same as condos. So my understanding, and we haven't had time to go through the thousands of files in the past, but when I talked to the planners, they said, yes, we recall doing it both ways.
So given that response and looking at the letter from the councilman of the district, who is very clear that he does want to see and fully expects that the community fees would be paid, I would move to deny the appeal filed by R.E.W. DeSoto Partners, LLC, and Josh Bassbinder on behalf of Warner, and thereby sustain the decision advisory agency in approving the modifications vested tender tract number 69061 M1-M1, composed of two lots located at 6205, 6219 DeSoto, Woodland Hills, for the proposed construction of maximum of 707 residential apartments units, including 312 senior apartment units and 395 market rate apartment units, subject to modified conditions of approval. To the applicants, I always put a lot of weight on the councilmen of the district. And knowing what their challenges are, their subjectivity in relation to could-be funds and development, they are the stewards of the district. And so I'm following his advice, knowing that the staff has been engaged in this issue and seeing how the staff is struggling to maintain some consistency. As policymakers, maybe we need to break that down to start identifying how it applies to apartments versus condos, which is the gray area that seems to cause this inconsistency. So that's something that I think we're accountable to. Colleagues, any questions? Do I have a second?
Just one question that, and I'm not sure if there's an opportunity to come back or maybe even bring it to council as a written opinion from the city attorney. If it's been stated that we've done it inconsistently in the past, I think we've got to also look at what those inconsistencies were, not just that perhaps it was a mistake, but it could have been a policy decision on a particular project that have similarities. I just don't know. I don't have enough information. And so it's easy in hindsight to look back and retrospectively say they were mistakes, but in fact they could have been by legislative action because of similar situations or not. So I'm looking for the consistency and the correct legal way to do this as well. I would be more comfortable in moving this on to council with no recommendation, so we can allow a written opinion from the city attorney to research this, because you stated you didn't have time. And I think we've got to err on the side of caution to be business friendly and protect the community. That's how I read into the letter as well, and not just a cursory view of what the code says, because I know there's a lot of ambiguity there. But that would be then my recommendation, and I think that would give us that time, if that's enough time for the city attorney to do additional research.
This item, Councilman, is scheduled in council June 26th, so that's next week.
Is that enough time to take a look at this a little further?
I think I would ask that we get more time because we have to discuss it within the office.
Well, I think
we
it's
have
too
done most
big
of
of
the
an issue.
research.
What's the time frame? What are the limits? Madam Clerk? Because I don't want to lose discretion if we... as she's looking, go ahead.
Okay. I'm sorry, I wouldn't interrupt you. With all respect to the planning department, there haven't been just a few cases done this way or that way. Hundreds and hundreds of cases for 4 decades have been done the way that we're asking it for it to be done. This isn't maybe yes, maybe no. And as a matter of fact, I asked them about, well, because I give a lot of money to 501c3s for affordable housing, Skid Row housing, et cetera. And I said, so if I want to build Skid Row housing and I want to donate to them, do they now have to pay Quimby condominium fees, $4,500 a unit. They thought, oh, planning said, that's interesting. That's an interesting question. We've never done that in the past. So when we talk about mistakes, we're not talking about one mistake or two mistakes. We're talking about 40 years of the same thing. The second thing I want to talk about is with the city attorney's office, with all due respect. We have been talking to the city attorney's office about this for months. So they have written several long documents about their opinion of this issue. This isn't something that all of a sudden they're going to start doing some research. Had the city told me that this had to be a different way, I would have done it differently. We are in a very tough position today because we relied on what the city attorney had said at the time and what the planning department said at the time. Now I know going forward, my expectation is that Plum will reevaluate how to assess these fees. Maybe apartment fees go up and Quimby fees go down, and everyone has to pay the same fee because a dwelling unit is a dwelling unit. But for this particular case, we've got dozens of guys out there working. We relied on this. The bank relied on this. That we weren't going to have to pay Quimby fees, and now where's all this money supposed to come from? Because we relied on this. Going forward, I get it, and I have project going forward. I know what my expectations are, but it's not fair that this project is stuck.
This is the problem that I'm having, is the problem with the city of LA, that they constantly, there's so many different staff looking at it from so many different perspectives. It's just no way to operate a business to be business friendly. And so what was the date that we could look at? And you said the 26th is not enough time for the city of
I'm checking with the clerk, and the deadline is the June 26th for council. If we get an extension from the applicant, does that make a difference? Okay.
The other issue, Councilman, is that if we have to extend it, we will extend the time. But as you know, this was extended many, many, many times already, and we have financial issues and situations that we have to deal with and deadlines that we have to meet.
Well, it wouldn't be an extension coming back here. It would be extension for council.
Oh, no, I understand. But if no...
The bottom line is, the bottom line is this, is that Councilman Zine, Councilman of the District, expects the Quimby fees. That's his expectation. But I'm just telling you what is written in this letter.
I believe, Councilman, it says, if any time the map is utilized and the units are offered for sale, I fully expect Quimby units are to be paid. I interpret that, just I do, that if it's apartments, then you pay the apartment fee.
Mr. Mensman, can you tell me how we interpret your boss's letter?
Yes, sir. I'm sorry. Doug Minson speaking for Councilman Zine. Yeah, the intention, and that's the reason why the letter is written that way, is if the units are offered for sale like a typical subdivided airspace condo, that Quimby would be paid, right? But that apartments, units, rental units would be
Okay, so let's cut to the chase. You want to deny the appeal, or you want to support the appeal? What do you want to do?
The councilman would like for this appeal, I guess, to be denied. I'm sorry, granted.
In part?
In part.
And denied
on
in
this,
part.
right, exactly. On that topic there, of that if the units are built under an apartment building permit, that duct applies and Quimby would not.
Okay.
Was our understanding of the meeting.
I'm fine with that. I am fine with that. I just want to get to a decision. So, given Councilmember Englander's
My first motion.
we would grant in part, deny in part, and that allows us the flexibility they're seeking. I want to have committee act on this action.
Okay.
So what I understand is we could grant in part, deny in part. If we partially agree, the appeal filed by REW DeSoto Partners and Josh Bassbinder on behalf of Warner 2D EP LLC, the applicants, for the post-construction of the project as described. That would be the action of this committee. It would satisfy the needs of this committee. I'm asking City Attorney and CLA.
Correct. In addition, I don't know if the committee would like to move with Mr. Englander's request for the city attorney report before the matter reaches council.
I'm assuming we got till June 26th.
Okay. I will relay that matter back to my office.
Okay. So that'll be the Actions Committee, grants in part, deny in part, and we'll follow that.
And then if I could just add one thing to it, I'd like to ask this committee to ask the Director of Planning at some point to report in the near future back to this committee on these ambiguities and trying to iron out policy on so we don't have these interpretations in the future. And it's crystal clear of what's expected from businesses, people trying to do business in the city of LA, and they don't have this back and forth unknown when they've already gotten loans on properties and they put people to work.
And along with that report, identify the status of the 501c3s. If it's the 501c3 nonprofit, are they required to provide permit fees or not? These are the inconsistencies that we need to do away with. So we get a report back on those items. Okay?
Thank you.
All right. Thank you. That's action of this committee. Okay. That takes us to some might call the big ticket item. Items 4 and 5 we'll take together. Can staff give us the commission report and the staff recommendation?
Good afternoon, committee members. Lucy Ibarra with the Planning Department, Major Projects. Before you is a City Planning Commission determination on a property at 1720 through 1770 North Vine Street, properties along Ivar, Argyle, Yucca. The City Planning Commission at its hearing on March 28th approved a vesting zone change, a height district change, a vesting conditional use, master conditional use, and zone variances relative to the mixed-use development of, 492 residential units, a 200-room hotel, approximately 100,000 square feet of office, 35,000 square feet of sports-related club, 15,000 square feet of retail uses, and 34,000 square feet of food and beverage uses within 2 towers, one at 55 stories and the other at 45 stories, along with the associated development regulations and the land use equivalency. They also denied the appeals that were filed to the vesting tentative tract map that was heard and approved by the Deputy Advisory Agency for the development and the subdivision of these properties. The Planning Department recommends the City Planning Commission project, finding that it was consistent with the Regional Community Center land use designation and the zone, and was consistent with the Hollywood Community Plan.
That's it? That's everything? Okay. Are you sure?
Unless you have questions.
Questions, staff? No? Okay. Thank you. Let's hear from the appellants on record.
My apologies. I forgot to add, following the issuance of the determination of the City Planning Commission's action, Planning Department staff reviewed the determination letter and the development regulations, and we found that there were some typographical errors, some formatting issues, page number issues, and there were references to a development agreement that has since been withdrawn that we wanted to correct. And so we provided a memo here on behalf of the department and planning staff relative to those corrections.
These are technical.
Right.
Okay. Okay. All right. Thanks. Okay, so we have appellants on record, Community United for Reasonable Development. Are you here? Like to speak? Let's hear your point of view. Reason for your appeal.
Thank you. We are appellants in items 4 and 5, and I would respectfully request that we be given at least 10 minutes to present our objections.
Well, why don't you start and let's see how far you get.
Thank you. Robert Silverstein of the Silverstein Law Firm, appearing on behalf of Appellant Communities United for Reasonable Development. That is a coalition of more than 40 community associations opposed to the project and the EIR before you. Collectively, these groups represent more than 250,000 residents in Hollywood and the greater Los Angeles area. Let the record reflect that I have handed in a letter, which I'm also holding up today. That letter has 27 exhibits attached to it, and that has been provided to each of you, honorable members of the Plum Committee. I would respectfully ask that you give great consideration to these arguments prior to any decision being made. And when you do finally make a decision, I am confident that you will conclude that the Millennium Project violates state law, CEQA, the LA Charter, and the LA Municipal Code. A significant portion of the material that's in the letter before you relates to seismic issues, and that is an issue, the importance of which we did not grasp until approximately 2 weeks ago, when we discovered that a study had been prepared by the Millennium Consultants geologist, which had not been made public, and in fact which had been suppressed. It was not circulated, it was not part of the technical appendices attached to the EIR, it was not referred to in the draft or the final EIRs, and we in turn hired our own certified engineering geologist to analyze the seismic issues. And I'm here today to tell you that there is something very rotten in the state of Denmark, also known as Hollywood, with regard to seismic issues, that no matter how great somebody thinks this project is, no matter how wonderful of an investment or an improvement or whatever benefits it might supposedly confer on the community, it cannot be approved, because the truth is that there are active fault traces of the Hollywood Fault crossing this property. This is not just an issue of disagreement among experts. This is an issue that was well known to the developers' consultants and was kept out of the public record. The planning staff, whether through negligence or incompetence, I don't believe it could be either, because the data out there is so public and peer-reviewed, has allowed this to get this far. You, as stewards of the public good, have to look at this and stop this process now. Let me be a little more specific with regard to these seismic issues, because they are earth-shaking, literally and figuratively. George Abrams, who is a longtime resident of Hollywood, got wind of some issues, questions about seismic, and he contacted a Professor Dolan at USC, who is the recognized national expert on the Hollywood Fault.
For the record, who's George Abrams?
I'm sorry?
Who is George Abrams, for the record?
George Abrams is right there. Let the record reflect.
Who is he?
He is approximately a 50-year resident of Hollywood.
Okay.
He's also an officer of the Beechwood Canyon Neighborhood Association, and he is a prominent activist. He also may be somebody who has saved thousands of lives because of the discovery of this seismic issue. He contacted Professor Dolan of USC. Professor Dolan of USC's jaw figuratively dropped when he learned what was being said about the supposed non-existence of the Hollywood Fault across the site. We have attached all of Professor Dolan's emails to us at Exhibit 24, and we urge you to read those. In polite terms, but nonetheless clear terms, Professor Dolan basically says that a fraud has been committed on the public in terms of the complete lack of disclosure of well-documented studies and fault traces on the property. We discovered this again all of 2 weeks ago, and we've been busy trying to present the most comprehensive set of objections that we can, so that you can make a decision based upon the proper information before you. The problem with the EIR is that it doesn't serve its fundamental purpose of being a proper information disclosure document upon which both you as the decision makers and we as the public can make informed decisions. What we have done is try to fill in those rather enormous gaps in the data that was before you until now. What's really amazing here is that the EIR and the studies prepared by a firm out of Irvine called Langen Engineering that was hired by the Millennium Consultant failed to recognize, mention, or disclose that for the past 20 years there have been peer-reviewed studies, including from Crook and Proctor in 1992 and Dolan in 1997, which map active fault traces across the property. What did the Millennium people do? Well, I'd like you to take a look at an exhibit that I have prepared, because the Millennium folks falsified a map and showed, yes, I say that with 100% confidence and no hesitation, falsified a map which depicts the subject property as being 850 feet north of where it actually is. And I'll show you, and I will show the audience, the black lines here represent the city's fault rupture study area per the general plan safety element. The blue polygons represent what was shown to the public and you in the EIR as supposedly being the site of the Millennium Project. The red square rectangle is the actual site, which is right through the black line. So what's happening here? Figure 2. We've taken the Langen May 2012 study, the one that was part of the record, not the November one that was suppressed. And what we've done is, the blue polygons are what were presented by Langen. And those blue polygons did not have the street map. What the street map is our geologist, to scale, superimposed the street map to show the actual location of the subject property. Langen pretended that Yucca wasn't there and shoved the properties, the blue, up to the north near Franklin to get it outside the fault rupture zone. What the red rectangle shows is the actual location. So you have before you something that was what we would call tampered with. And why don't you turn around and show the audience? So the blue is what the EIR falsely claims. The red is where the property actually is. The black is the city's own fault rupture study zone, which means there has to be a fault investigation done, and it has to be a proper fault investigation. This is no accident. This cannot be attributed to mere negligence or incompetence. That's number one. Number two, not only did they fail to cite the Dolan studies and the Crook and Proctor studies, but unbelievably, the 2010 California State Geological Survey map, which shows the Hollywood Fault crossing the subject property, was never mentioned in the studies. This is not, again, a disagreement. This is the California Geological Survey's 2010 map, which is considered the Bible of geologic issues. To somehow pretend that it doesn't exist and to not mention it is completely unacceptable.
You said the same thing several times now, different ways.
Okay? The
So
black...
Can you move on to other points?
Yes.
Because you're losing your time.
So the black line there, George, if you could just show the audience also. The A represents Hollywood and Vine. Project site is just north of that. The black line from the California Geologic Survey is the Hollywood Fault, which is active, which the MTA has said in their EIR.
You made that very clear.
Okay, I didn't mention the MTA, but in any event, I think we get the point. And the third, I'm gonna skip it. It's in my letter. I trust that you will read it, given that
As
we
you
don't...
just gave it to us. Yeah, we're looking through it right now.
Right, and we just, only figured this out. But we trust that you aren't going to want to approve basically a 55-story tomb on top of an active earthquake fault. Okay, continuing briefly. There are several CEQA issues that I have included in the letter. I'm only going to hit a couple here for the sake of time. Number one, CEQA's under attack because people claim that it's being misused to stop good projects. First of all, this isn't a good project. It's a calamitous project on top of an earthquake fault. But second of all, remember that sometimes other governmental agencies actually weigh in and say, wait a minute, this is a bad and dangerous project. And what you have here is Caltrans, a sister agency, which is called a responsible agency under CEQA, weighing in and saying over and over in written comments to the city that this EIR is facially inadequate, fails to respond to Caltrans's comments, and should not be approved. Caltrans has also complained in writing that the city has ignored Caltrans's comments and has failed to proceed in the manner required by law. I would respectfully tell you that when another agency like Caltrans weighs in and says, stop, this is bad, this is harmful, and this is illegal, you really need to listen. So far you haven't. I'm here because Caltrans, I don't know if they have a representative here. I know they've appeared in writing, but I'm here to emphasize their points. Under CEQA, as a responsible agency, Caltrans has the right to tell you, the city, the lead agency, the contents and the scope of information that shall be in the EIR. Caltrans specifically demanded that you analyze the impacts to the 101 freeway based upon the highway capacity manual methodology, not based upon the congestion management program methodology. Sounds very esoteric, sounds boring, but Caltrans is telling you the right way to do it, and the city hasn't done it. On that basis
I
also...
highly recommend you start concluding.
On that basis also, this EIR is improper. We've also put into the record information from the fire department. Not too long ago, the fire department made a public announcement that all of the data on response times that the fire department had previously submitted to the city was not reliable. That's their words, not reliable. Everything in this EIR is based on that now expressly repudiated data by the fire department itself. There has not been an adequate analysis of fire and safety response times and the impacts to fire and police services.
Okay.
On that basis as well, the EIR has to be
Are you
sent
finished?
back. If you would like, I will cut it shorter.
Well, you're already down to 10 minutes, so.
Okay, if I may.
So you're done.
Okay, I appreciate that. But I also appreciate you giving us due process. This is obviously extremely important.
Yes, and that's why you got the 10 minutes you asked for.
Thank you. I should have asked for 20.
You would have gotten 5.
Bill Roshan. Bill Roshan is the president of the Planning Commission. At the Planning Commission hearing a couple months ago, the city attorney correctly announced that Bill Roshan had a disqualifying conflict of interest because he was financially interested in the project as a consultant to the developer. As a result, the developer withdrew the development agreement but proceeded with the rest of the project entitlements. That is not good enough. The city attorney only got it partly right. The other entitlements are a contract because everything at the end of the day is reduced to what is called a covenant and agreement. That covenant and agreement has the same force and effect as the development agreement in terms of it being contractually binding. What that means under Government Code Section 1090 is that every decision that was made by the Planning Commission is tainted by Roshan's conflict of interest. The taint was not cured or removed solely by excluding the development agreement. It has to be redone entirely, and this process does not cure the prior infirmity. Otherwise, Section 1090 would be meaningless. To conclude,
Thank you, sir. To conclude. Final sentence. Let's see if you can do it.
We appreciate your time. We ask you to give this serious consideration, especially regarding the seismic. On behalf of Appellant, its constituent groups, dozens of supporting neighborhood associations, and hundreds of thousands of City of Los Angeles residents, we urge you to reject this project and the EIR.
Thank you, sir.
Thank you.
Thank you very much. I have one question. Please, my colleague has a question for the speaker, please.
On the issue of the fault, are you claiming that you're asking the city to investigate, or do you know already whether it's active or inactive, or what is the actual status of the fault?
Well, the status of the fault is active. There's no doubt, even in the city's recent EIR on the Hollywood Community Plan update, that document by the city acknowledges that the Hollywood Fault is active. Nobody denies that. Active in seismic terminology is defined as any movement within the last 11,000 years. And it's moved plenty, much more recently than that. So number one, the city's own documents acknowledge that it's active. There's no dispute about that. The MTA, EIR, and EIS for the red line similarly said that the Hollywood Fault is active. It also said that there is a 5% chance of a 7.0 earthquake in the relatively near future. So in terms of activity, that's not even in dispute. In terms of what am I asking, what I am saying is that the EIR is invalid, verging on, fraudulent, because of the way that the information was suppressed about the Hollywood Fault, because of the way that they falsified the location of the site, because of the way that they falsely claimed that the fault was 0.4 miles away when it's not, because of the disregard of the Dolan and the Crook and Proctor studies, because of the disregard of the California Geologic Survey map, which shows the fault running across it. They can't build a doghouse on that property, respectfully,
Thank you.
and they know it. Now you know it, and we're asking that you do the right thing.
Thank you. And now to our city attorney, did we evaluate the Section 1090 assertion, and where are we with that?
Oh, I believe that we have, but I will go back and discuss it with the city attorney that was at the City Planning Commission meeting. I believe that entitlements are different from a contract, such as a development agreement,
Okay.
but I'll confirm that.
Okay. Thank you.
A quick question. First, an observation on your Exhibit 3 that states the inadequacies that you addressed in the fire department. You included, in fact, the entire analysis and the fixes from the fire department in the report, identifying the updated CAD systems being put into place, further identifying the fire stat LA system being put into place and adopted by the council and the city, the fix in their what they put together to accurately reflect all the current data and backlog the data to fix the underlying issue of what was wrong with their data, so it didn't include the additional reports. The fire department actually corrected their action and have true baseline data retrospectively, but just so you might want to update that. On the safety element, on your Exhibit 16, basically on a lot of the things you're saying about the fault lines, and I pay careful attention to that, particularly as I represent Northridge earthquake area, which we're coming up on the 20-year anniversary on, and reading through it, I'm very familiar with these studies as well. One of the interpretations of your analysis is actually highlighted in the report that you submitted, but basically says that the entire city of Los Angeles poses the same seismic threat. Every part of the city, regardless of the underlying geological and soil conditions, and that, in fact, these faults and thresholds, whether active or inactive, in fact, pose a significant risk, and the entire city of Los Angeles is at that risk. In fact, it's been further stated by the experts, Dr. Lucy Jones of the U.S. Geological Survey and others, that it's not a matter of if the big one hits, it's when, but it's going to happen here, anywhere, at some point in time. But you're pointing to this one particular area. I just wanted to show fault in your study that, there's a true threat, but it's everywhere in Los Angeles.
Can I
not to make you any more comfortable, but it was just my analysis.
It's just an observation.
Just an observation. But thank you very much.
Thank you. Thank you. We've given you ample time. We have another appellant that we need to hear from as well. I believe we have Mr. Resnick representing the other appellant.
Good afternoon. The appellant, I think you have the corporate name just for the record, so we should note I represent the W Hotel in Hollywood and the residences at the W Hotel. I'm Ben Resnick with the firm of Jeffrey Mangles, Butler and Mitchell. We have filed letters and objections dating back to the comments on the EIR and the Planning Commission. Let me just start off by saying my client is supportive of development in Hollywood, in seeing Hollywood continue its development, and seeing this very site be developed. The problem our client has is that there is no known project in front of you. What you have and what the Planning Commission approved is basically a blank envelope, carte blanche, for this applicant to be able to build whatever he so chooses in the future, within a framework known as trip caps. The only thing limiting here is the number of AM, PM peak trips. But this development can be anything. This development in the future is not tied to anything. This is 1,160,000 square feet of development. Basically, we don't know what it's going to be. This could be a height of anywhere from 220 feet to 585. This could be 900 residential units or 0 residential units. This could be 200 hotel rooms or 0 hotel rooms. This could be 215,000 square feet of office space or a lot more. This could be any combination you can think of. This could be the 2 spiral towers you see, or this could be something completely different. There is nothing to lock in this project into any sort of review. What you're approving is a carte blanche envelope. It's never been done this way in the city with this size project, for sure. So, for example, they want to apply in the future for alcohol permits, restaurants, and all of that. There's a condition, condition 3, that says they'll come in for plan approval every time they do that. But there's nothing to allow any sort of review for stakeholders in the area to see what they're actually going to build. They can literally walk in under this set of entitlements and pull building permits and build what they so choose to build. It could be half the height of the building, but it could cover the entire podium or the deck. And so our concern is that we don't know what it is we're being asked to approve, support, and we've raised this issue before, and hence we're in a position of saying we can't support a project that is a carte blanche development of this magnitude of this size. Okay. So at a minimum, there ought to be some conditions imposed that as the project shifts or changes, whatever it is that they're willing to commit to today, because you saw how short the staff report was. That's because there's no real project to give you that's committed to. So if there should be subsequent plan approvals, subsequent community reviews. That doesn't mean they have to go back and start again. They'll have a certified EIR maybe. But there's a problem too. The EIR is not a project EIR. It's a program EIR. It analyzes all sorts of options, but it doesn't analyze a project. This project, or whatever it is that this is. And so we find ourselves in this awkward place where we've actually asked this developer to commit to a project, show us what the project is. We've seen pictures, but when you read the paperwork, when you read what was actually approved, it's carte blanche. They can do anything they want. And so we oppose based on that basis. And based on that, the EIR itself is defective because there is no specific project description. And so hence, we think that it's a terrible mistake to approve something of this nature. And it's being done under what we call the land use equivalency program. If that's the future of the city, if that's the way applications now will get filed, then basically you're wasting your time with public hearings, aren't we? Because it's going to be here. Just give a set of limits, and in the future the developer can build whatever he or she chooses. So that's our objection, and with that we ask that the project be either returned for a real project analysis and a commitment, or that today some commitment be made to a specific project, and if that's going to change, require a plan approval review in the future. Thank you.
Thank you, sir. Okay. All right, folks. Still got a few more steps to go through, so I appreciate your cooperation. We will now hear from the applicant, then we'll go into public comment. Applicant, would like to come on up and give us your response. Do we have another appellant? I think that's enough. There's 2.
Good afternoon, members of the Plum Committee and others, and thank you very much for the opportunity to be here today. My name is Philip Ahrens. I'm a founding principal of Millennium Partners, who along with Argent Ventures are the developers of the Millennium Hollywood project. When Millennium acquired the Capitol Records project, Capitol Records building and the adjacent underutilized parking lots 6 years ago, we started a dialogue with the planning department, elected officials, and neighborhood groups to determine the best design for a project that would preserve Capitol Records, preserve the views, historic views of Capitol Records, as well as create a transformative, transit-oriented project at one of the most famous intersections in the world. We had numerous meetings with neighborhood groups and the council office for CD13, both current and future, and have studied a variety of possible design solutions for this exciting mixed-use project. I would like to ask Gary Handel from Handel Architects, who along with Roshan Van Cleve are architects for this project, to present the design as originally approved by CPC and some lower height alternatives which we have studied that address the concerns of our neighbors and the council office. Thank you.
Thank you, Phil. Council members, my name is Gary Handel, founding principal of Handel Architects and a member of the design team. Next. And so the guidelines and standards actually represent a robust framework of rules that govern development on the site. The design guidelines and standards themselves are a 61-page document that encompasses hundreds of rules and regulations that are tied together to achieve the development objectives that have been agreed to by the developer, planning, and the community. In addition, working with planning staff over the years to bring this project to you, there are approximately 80 pages of conditions that basically further restrict the development. And so those design guidelines and standards govern a number of things on the site and actually mandate a project of a certain quality and that it needs to behave in a certain way.
If I may interrupt, if you could try to answer some of the assertions made during the...
So the first assertion is that there is nothing that governs development on the site. And so the guidelines and standards are actually a legal framework that we need to exist within in order that any development on the site can be measured against. Next. There are a series of objectives that basically guide the design guidelines and standards. Next. And basically it does allow for a certain programmatic flexibility, with the idea being that the development on the site would produce a vibrant mixed-use development that can be built within this economic climate. Next. It governs specifically where tall buildings can be located on the site. So if you look at zones B and C, those are the areas where towers can be located on the site. Zones A and D are lower height districts. This is in line with the Hollywood Community Plan, which basically sets forward Vine Street as an appropriate corridor for tall buildings. Next. It sets forth street wall standards that basically mandate that retail and other active uses will line the streets and passageways, as well as establishing public open space. Next. And it creates a binding formula for basically lot coverage, open space, and height. And so while the project next can exist at a number of different heights, at those different heights, it needs to provide different things. And so this is a complex document that has been negotiated with planning, with the stakeholders, and with the electeds to govern development on the site. Next. In order to illustrate that, we did a series of views that basically would show how the project would perform at different heights. So at the 220-foot height, go back please, you see it occupies more lot coverage, so that basically it is a bulkier building. Next. At a higher height, it pulls back and more open space is provided. Next. And that at the tallest heights, it occupies the least amount of site footprint and more public open space is provided. These are binding requirements. From the Little Country Church across Argyle, a similar series of views. So the project at 220 with its required open space, at 400 with its open space, and at 585, again, occupying the smaller portion of the site with more of the development organized into tall, slender towers. Next. It actually sets out rules for urban design and architecture. Next. It mandates that the podiums will be organized according to appropriate neighborhood datums with higher podium heights on, fronting onto Ivar and to the east side of Vine, lower heights onto the east side of Vine and onto Argyle. Next. And it allows for the creation and mandates a through block connection of public open space that can then be extended next to the parking lots to the west and eventually tie into the Hollywood Cap Park next. The open space itself basically was shown, and this is at the tallest height, with a series of public open spaces working our way from Argyle to the east next, showing the lounge next, the garden next, and then the stage which fronts onto Vine Street next. And again, a view of the stage next, and across the street on Vine Capitol Plaza next. The towers themselves, basically there are articulation standards within the guidelines that basically the idea is to not produce the standard residential slick glass tower, but something that's more articulated. This is Pierre Koenig's case study 21 next. Taking that into building form next, into aggregate form next, and then into towers. We met with the Design Review Commission. There were suggestions on our peer group review that we provide an alternate palette, which has been put into the planning document, and so that there are material standards that will have to be followed for any building that is created on the site. Next. Next. And so this was the scheme that was approved at planning, and then working at the suggestion of the council, we looked at some lower height alternatives next. And you can see, and so go back. So the initial study is at 55 and 45 stories next. And then alternative 1 reduces the building height to 45 and 39 stories next. And then alternative 2 further reduces the height to 39 and 35 stories next. Similar view, this is a view of the city planning approved scheme next. And then a reduction to the 39, 35 in this case next. This is a view looking towards the south next. And this is the reduction in the first reduction next. And then the second reduction to the 39, 35 next. On the open space, this is the approved open space from the larger scheme, and then next. And so the attempt has been made to maintain the principles that were established in the larger scheme in all of the schemes, fully following the guidelines and standards that are established for the site. And so you can see this, go back. So this is the first alternative next. And then this is the 39-35 alternative. All of the elements are there. The open space is slightly reduced in order to accommodate a slightly bulkier podium. Next. And then some views of so this is the view of the stage from in the CPC approved scheme. Next. And then this is alternative 1. Next. And then alternative 2 with a slightly bulkier podium. Next. The CPC approved scheme next, the redesigned project at lower height next, and again a view looking back across Vine Street, and then with the alternative scheme next. This is a view looking up Vine Street towards the Capitol Records building in the CPC, go back, the CPC approved scheme, and then the revised alternative next. And then go back. Yep, sorry.
Are we done?
Almost. So there, go ahead. And then a view of the CPC approved scheme, the alternative scheme, Next, the view of the observation lounge, which is a requirement of the project. Next, that at night. Next, and that's the close. Thank you.
Thank you, sir. How much more time?
Councilman Reyes, members of the Plum Committee. My name is Jerry Newman, representing the Hollywood Millennium Project. We'd like to run through a couple of responses to what you heard from the appellants. My partner, Alfred Freiho, would like to present a letter that we have provided you relative to the responses to the written appeal that we saw, as well as we have a writing relative to the amount of some corrections that we would like to see from the Planning Commission approval.
So give us the Reader's Digest version. Right?
The Reader's Digest version.
Okay.
I think you may have questions. I'm going to first address. Why don't I let Alfred go first and run through the Reader's Digest version of those issues,
okay.
And then I'll come back and address responses to what the appellant said in the last.
We're going to keep it within 4 minutes because that's within the 10 minutes I gave the appellant. So keep it fair.
Thank you, committee members. Alfred Fraulo, Land Use Counsel for the applicant. I simply wanted to raise a couple of points really quickly. We did submit a written letter in response to all the objections that were raised in the appeal for your consideration in May, in advance of the hearing, unlike our appellants, for your consideration. And the issues, to conclude and sort of summarize in a nutshell, the issues that were raised are not new issues that have not been considered by the EIR. The appellants have been working with a series of stakeholders, as was mentioned. They submitted a series of comment letters, and those comment letters were adequately addressed in the EIR. The major points that were raised in terms of objections was this issue of specificity relative to the project description. This is a project-specific EIR. The notion of an equivalency program is not a new program, as both of you know. It's a program that's been used as a lead agency, the City of LA, for various projects, projects that of this scale that require the kind of consideration, both in terms of the uses that are considered. It's a transit-oriented development with the range of uses. The equivalency program allows a series of changes, and as a result, the EIR takes a conservative stance relative to those changes, meaning that we studied the most potentially impactful scenario relative to those modifications that are adequately addressed in the EIR. And we're confident that both in terms of precedent by the lead agency and on the basis of case law that we are within the range of what CEQA permits. With regards to the Q condition, which is another important issue to raise with you today, there is a argument that somehow because of the removal of the development agreement and the Q condition that allows for the flexibility relative to the development regulations that have been presented, that were presented by our architects. The Q condition in the municipal code is designed precisely to add specificity with regards to development standards for projects that are before the city. And so in that respect, the requirements that are found in the provisions of the Q condition is that the project comply with the general plan, that with respect to those additional development standards, that they be designed to provide further guarantees to the city relative to what is going to be built. And in that sense, the project complies with those additional requirements in the Q condition. Finally, to turn it over to my colleague, I wanted to just alert you to the series of modifications that we are requesting. Again, that was already presented for your consideration. And they relate primarily to a couple of additional issues that came about since the Planning Commission unanimous approval. Namely, there were a couple of changes with regards to the terminology in the development regulations that we thought were appropriate. One example of that was with regards to the use of the term street wall as opposed to podium, and we wanted to make sure that there was some consistency around that. There was also two provisions in terms of the conditions that were required that after consultation with Metro, Metro gave us some input, and as a result, we wanted those conditions modified as well.
Okay. So let's keep it short.
And those, again, the series of requested changes have been submitted for your consideration and have been discussed with the Planning Department. Thank you very much.
In terms of the specific issues that were raised today, one, the seismic issue, and two, the not knowing what the project is, I think Mr. Fryho already discussed the fact that this is the most, as you look at the guidelines, this is actually the most overstudied, overregulated project that the city has ever considered, and it provides greater tools to the city and city planning department than they've ever had in trying to provide projects that can both meet the needs of the market as well as respond to them appropriately on a timely basis. Relative to the 1090 issue, the city attorney has reviewed that issue. While we provided opinions that we didn't even agree that there was a conflict relative to the development agreement, out of an abundance of caution, the development agreement was removed. There is no 1090 issue relative to the specific standards of passing entitlements on a project, irrespective of whether a covenant is recorded or not. I'm not going to go into the fire department issue, as I think Councilmember Englander has already discussed that a little bit. On the seismic issue, I want to be clear as to what exactly that issue was discussed. It's interesting that Mr. Silverstein's own charts have different locations of the fault lines. So where he says that things have been changed by us, which is completely and utter falsehood, the reality is even his own charts indicate different areas of the fault. Now, the reason for that is as we've gone through the process, the City of Los Angeles has been waiting for the state to undertake its new fault study, which the state is undertaking. The city has never done its own fault study. And to say that the faults are active, one, is completely erroneous. There is no document within the city that determines that there is any active fault within the area. We did specific studies at the request of the planning department, voluntary studies relative to our EIR, and did specific borings across the entire site to determine whether or not there was any evidence of a fault within the area. Those studies were included in our EIR, and you can see those studies. In addition, and this may be where there's some mistake relative to the thought that we had some secret study, the planning department, as part of our track map, requires additional studies to be done relative to specific building on a tract, and that is part of their tract conditions. So they requested that we go back and do additional borings across the site to determine whether or not there is a fault. The state currently has an idea that the Hollywood fault extends to the north boundary of the property and then comes southward, and we didn't know where and if it intersected the property. What our boring showed as we crisscrossed the site in borings was that the fault was not evident in anywhere on our site. That study was not included in the IR because it was never part of what were the requests and the scoping of the IR to begin with, but it was a requirement specific relative to building and safety and their analysis of our track map. And so that's why you hear that there may be two different studies. The reality is, at the end of the day, the site is overstudied. It has been studied to an incredible extent, borings across the site determining that there is no fault on the property.
So there is no building being built on top of a fault?
No, there is no fault line that actually crosses the boundary of the property. There is no evidence of any fault on the property.
If there is, do you know?
If there is one determined, for instance, if you ended up excavating and found a fault that was active, one, it has to be younger than 11,000 years old for it to be considered active. If in excavation that was discovered, there are regulations that regulate where a building can be built relative to a fault line, and we would have to adhere to those regulations, and that's part of what the building and safety study was meant to determine.
When we are building schools for the LUSD, we had a number of cases like that, and there are some guidelines as to how far away you can
exactly.
From a fault, but there's no fault near the site.
There may be a fault to the north of the site, we don't know, but nowhere that is close enough to change the building regulations that is part of our proposal at the moment. Okay. Thank you. We would request that you deny the appeals and that you approve the Planning Commission, subject to any discussion that the council office may wish to present to you today.
Thank you. Okay. We have a lot of cards, folks. I'll be here till like 9 p.m. Just kidding. We do have a lot of cards, though. Let's go with 20 minutes each side, and let's see how far we can go. So when you do come up, the shorter your presentation, your statements, the more people will be able to speak. We are going to limit every speaker to 1 minute. If you don't have to take the whole minute, more people can be heard. If you are in agreement with the previous speaker, you're fine to say, I agree with the previous speaker and give us anything else. Try not to repeat what was already said. I know this can be an emotional issue. If you wrote a letter, get to the point of the letter as quickly as you can. So if you just zero in on your main point on your letter and not go through the whole letter, you would save yourself time. So we're going to keep it to 1 minute. So let's start with those who mark opposed. And we'll start with Jack Humphreyville. Then John Hartman, you're welcome to come to the mic. Arlene Breams and John Girodo. Good day, sir.
Hi. My name's Jack Humphreyville. I'm with the Greater Wilshire Neighborhood Council. And on May 8th, we voted to oppose the Millennium Hollywood project as proposed. We also notified the City Council and the Mayor. I also wrote the opposition argument to Proposition A, the half-cent increase in our sales tax that would have raised $200 million. Prop A was rejected by 55% of the voters. Yet only 4 months earlier, 70% of LA's voters voted for Prop A, which raised $600 million. If you approve the Millennium Monstrosity, where the New York City developer makes $1 billion and we get nothing but gridlock and crumbs, you will alienate another high-voting neighborhood. Then consider all the other high-voting neighborhoods and homeowner associations that you have screwed. You have created a massive opposition to any tax increase you might propose, including, Mitch, your street tax. Is this the way Eric wants to begin his reign? Is this what Mitch O'Farrell wants to begin? Send the Millennium Project back.
Thank you very much.
Thank you.
John Hartman, Arlene Van Breens. John Hartman, are you here? Okay, Arlene Van Breens.
Yes, my name is Arlene Van Breems. Gentlemen, appreciate the chance to speak before you. I also had the opportunity of looking at the pictures that were presented to you, and I would request that you notice or pay attention to the fact that no cars were in any of the pictures. We who live in the hills, we drive. The city of Los Angeles is based on a grid that involves cars, motor vehicles. I use public transportation. I have a TAP card. And if you listen to Warren Olney's interview with the developer, he has absolutely no sense of how we get around in Los Angeles. He thought that these two towers would be icons for Los Angeles. He was very excited about that. We have our icons. It's the Hollywood Hills. It's the Hollywood sign. It's the historic Capitol building. Okay. And if on a night where the Hollywood Bowl has a crowd, 15,000 cars are getting to the Hollywood Bowl. We will not be able to get out of our neighborhoods.
Thank you, ma'am. Thank you so much. John Girodo. John Hartman, Alex Chavez, Robert Ajemian. Please come on up.
John Girodo speaking for Hollywood Heritage. Hollywood Heritage believes the Millennium Hollywood project fails to address the negative impact created by the mass and height of the proposed development on the Hollywood Boulevard Commercial and Entertainment District, irrevocably altering the character of this district, which is recognized in the National Register of Historic Places at the national level of significance. Hollywood Heritage recommends the following. The proposed towers should not bury the landmark Capitol Records building. To ensure its continued integrity, Hollywood Heritage recommends towers in the order of 150 feet to 220 feet, in keeping with current Hollywood high-rises. Number two, the Planning Commission should strike the permissive language in the draft approval allowing podium blocks at the bottom of high-rise towers, or should define podium more tightly. Another option is renaming podiums as the base of tall buildings and requiring that for the base of these tall buildings, street-scale architectural openings and street-level public spaces be designed to reinforce the historic district of Hollywood. Number three, an articulated street wall should be designed to reinforce the historic district. While we applaud the inclusion of open space, we would like to see the reintroduction of buildings along Vine Street. Thank you.
John Hartman. John Hartman, Alex Chavez, Robert Ajemian.
Thank you. My name is Alex Chavez, and I'm the president of the Hollywood Land Homeowners Association. Hollywood Land is a community located directly beneath the Hollywood sign and is comprised of 550 homes and 1,200 residents. We oppose Millennium Hollywood plan to build an oversized project in our community that will irreparably harm all the surrounding neighborhoods. And, I had a whole thing written here, but I'm not going to read it because, we oppose this project. Either one of you will be more than welcome to come to our neighborhoods, our hillside communities, Bronson, Argyle, Franklin, from 4 o'clock to 7 o'clock. Let's go now and take a ride, and you'll see the gridlocks, and you see what the situation in relation to mobility and traffic is around in that place. And this is just not something that should happen. And now it's in your hands, so we are waiting for your determination. Thank you.
Thank you very much. Robert Ajemian, Carolyn C. Letzinger, Ms. Fortune Zuckerman. Okay, sir.
My name is Robert Ajemian. I'm a volunteer with the Los Angeles Fire Department in the capacity of a CERT coordinator. And I'm concerned, I'm going to focus on just emergency response for the fire department. I'm concerned that with some 2,000 people in the new building, 1,000 people of the W building, and the fire department being instructed to cut down their response, that this is going to be an undue burden and will result in reduced effectiveness of emergency services. So I just am kind of confused why there's just been no traction on it. I have written about it to the council. I have spoken. And maybe just for a moment you could explain how it works, because it seems very important to me that there be a proper emergency response with this increased development. Thank you.
Thank you, sir. Another 1 minute. Great. Let's come on up. Carolyn Letzinger. We have Fortune Zuckerman and Stephen Poster, Linda, I believe it's Martyr.
Okay, my name is Fortune Zuckerman. The proposed project will change the whole face of Hollywood permanently. It will set the stage to turn Hollywood into a West Coast New York City. There are plenty of tall buildings in the world to see. There are plenty of tall buildings in Los Angeles to see. But there is only one Hollywood. I'm a 50-year resident of Los Angeles because I lived in a lot of other places, and I was born at the Good Samaritan Hospital, and I love Los Angeles, and I've been in Hollywood living there for 16 years, and I don't want it to change. This is my Hollywood, and let's keep it. Thank you.
Thank you, ma'am. Is Carolyn Letzinger here? Carolyn Letzinger. Okay, we'll just put that aside. Stephen Poster. Linda Martyr. Jim Van Dusen. Thomas Meredith. Michael Andreas. Hello, sir.
How do you do? I'm Stephen Poster. I am a representative of the Lookout Mountain Alliance. I am also past president of the American Society of Cinematographers, building at Hollywood and Franklin, an historical building. And the traffic at this point is almost impossible at certain times of the day. This building, without proper parking, without proper traffic studies, is going to congest the area in a way that will cost the city. In the long run, this is going to cost the city. No matter what you're making off of this, no matter what tax breaks we're giving them, this is going to end up costing the city. And I'm very concerned that it will change the life of the people that live in the area and the businesses in the area forever. Thank you.
Thank you, sir.
My name is Jim Van Dusen. I'm a member of the board of the Hollywood United Neighborhood Council and co-chair of the Plum Committee, representing 19,000 Hollywood stakeholders in the geographic area of this project. We oppose the unbridled, uncontrolled development represented by this project. Specifically, one, this is a project without a plan. It is outside parameters with no detail. No one on your committee or in the planning department has any idea what Millennium is going to build or how they're going to use the space around the Capitol Records building. We request that they present their planned building drawings for comment. Two, Hunk is on record with opposing a 6-to-1 floor area ratio, as it will far outstrip the ability of the area and infrastructure to absorb, and is inconsistent with the spirit and goals of the Hollywood Community Plan. Three, Caltrans stated the Millennium-sponsored traffic study is flawed, does not address the regional impact of this project. We request a regional traffic study and traffic management plan, as this project will impact the entire LA basin, since Hollywood is a regional traffic choke point. You're urged to vote to support elegant density and a 4.5-to-1 FAR. Thank you.
Thank you, sir. Come on up, please. Give us your name.
Good afternoon. My name is Tom Meredith. I am a 47-year resident of Los Angeles, 25 years in the Hollywood Dell, the community most impacted by unmitigated traffic. I also serve as the treasurer for Hollywood United Neighborhood Council, and today I speak on behalf of the Hollywood Studio District Neighborhood Council, for which I am vice chair. May the 31st, I sent you a letter that reflected a board opinion of opposition to the Millennium Hollywood project, citing certain conditions that we're all going to talk about here today, and you're going to hear many times. I'll just bring up the point that I think really resonates the most. The ERI, project's ERI states that the congestion is unmitigable. This is just not acceptable community planning, and I strongly urge that you reconsider moving forward on this. And it's important to note that I don't think anybody here is against development. It's just respectful development. Thank you.
Thank you, sir. Next speaker, we have Mike Andreas.
Yes.
Linda Martyr, one more time. Shelley Kia. Jamie McNary. And Ben Resnick, well, he already spoke. And Valerie Keegan. Good day, sir.
Good day. I'm Michael Andreas. I'm Whitley Heights Civic Association, native Angelino, and lived here for over 60 years, and have seen Hollywood go from a town that I thought would never come back to a vibrant city that it is now. And the reason it's vibrant is because it's Hollywood. People love Hollywood. And if somebody tried to put buildings like this up in a city like Paris, they would have each been given their cigarette and their mask, and they would have been put away, and the city would have been done with it. This is a land grab. This is just a way to make $1 billion. We don't need 1 million square feet of development in the middle of Hollywood. I had a meeting with them, with one of the people from Millennium, and I said, why do you have to build it so big? Why don't you make it something that enhances the city? They had no answer. We have to do it because they need to make the $1 billion off of it. Don't allow this to happen. This is a beautiful city. Hollywood's beautiful. You guys are responsible for it, and we want you to be responsible for it. We can develop on that piece of property without destroying the city that we're developing in. Thank you.
Thank you.
Hello, my name is Shelley Kaya, and I have been a homeowner in Whitley Heights, Hollywood, for the last 15 years. I agree that we need development in Hollywood, but it needs to be sensitive and sensible. And it needs to take into consideration the existing architecture, infrastructure, services, and icons, and Millennium is neither, and is not taking those things into consideration. Hollywood's not just a tourist attraction. It's not just a destination holiday. It's a community where people live, raise their children, and need services that are adequate to accommodate the residents and visitors. On any given day, traffic comes to a grinding halt, notwithstanding Hollywood Bowl, Ford Theater, or film industry events. Add the Millennium Project to this mix. We don't need the congestion and density a development of this size will bring.
Thank you, ma'am.
Good afternoon. Thank you for your time. My name is Valerie Keegan, and I am a many, many years resident of Hollywood, world-renowned Hollywood. Hollywood is a neighborhood. Today we are downtown. Hollywood is not a downtown, but what we do have are millions of tourists and visitors in Hollywood with the street shut down almost on a daily basis. I'm here to ask you to send this plan back because there is no plan. We don't know anything what's going to happen. We don't know the height. We don't know the scope. It was eloquently said earlier. Community plans are supposed to guarantee a certainty, to let us know what will be built there, what the density will be, what we need to be able to provide for that density, especially with police, fire, ambulances. Hollywood, we borrow ambulances and police all the time. We're borrowing from everybody all the time because we have more nightclubs than anywhere else in the city. We have over 550 liquor licenses in Hollywood. This density is out of scale. The height, you're asking for terrorist activity. Anything that would be built next to the hills,
Thank you,
please say no. Actually, I brought you some postcards.
Thank you so much.
So you'll have a little
Okay.
thing to remember.
So Jamie McNary, one more time. Barbara Whitkin. Barbara Whitkin. Are you here? Barbara Whitkin. Rosemary De Monte. Come on up. I call Jamie McNary, Barbara Whitkin, Rosemary De Monte, Chris Bonbright, Joyce, Director.
I'm Rosemary DeMonte. Barbara, I don't know if she wants to come up.
Come on up.
I represent the Greater Griffith Park Neighborhood Council, which has officially opposed this project. The geology reports are not complete. They have not finished the borings at all, so whatever they say. This will create traffic, and there are no mitigations even possible from this project. We are not against jobs. You can still have all these people working on a project that's 22 to 29 stories high, like the poor W followed the rules and they built. That would be fine. Now, what will be left after the good construction jobs are gone are the employed poor that will not be able to buy or rent in the building that they're working at. Why don't you build movie studios, build production, give the money to the production companies so that we have jobs that stay here and is good pay. Instead of building huge buildings full of people that are going to overtax our city services and our insufficient infrastructure today.
Thank you, ma'am. Thank you. Thank you.
I know one thing.
Thank you, ma'am.
That if this earthquake happens, it's 3 apartment building stories. No, it's 58
Ma'am, I'm giving everybody
story
1
tower.
minute, ma'am. Please. Thank you very much. Next speaker.
Yes, good afternoon,
Hi.
Councilman. My name is Joyce, Director. Hollywood is not New York. It cannot handle this big a development. Hollywood is a top destination not only for tourists, but the other T, terrorists. These buildings look like the World Trade Towers. And the line from that movie, Field of Dreams, with Kevin Costner keeps playing over and over in my head. If you build it, they will come. Make it fit into the neighborhood, not stand out like a sore thumb. It should be no higher than 22 stories. We're not against development. We just want it scaled down. We residents who live in Hollywood are the backbone of Hollywood. We love Hollywood. We pay a lot of taxes. We care for our homes, a lot of which are in historic areas. We are involved in our communities. We want the best for Hollywood. We have lived here for many years. We are not passing through the way these developers are. You hold a very important position. You are entrusted to look out for the interests of the public, of the residents in your district, and for the whole city, not for the interests and pocketbooks of the developers. Time will be the judge of your decisions you make.
Thank you so much.
Thank you.
The last call, Jamie McNary, Barbara Whitkin, and Chris Bonbright.
I'm actually speaking in favor of the project. It's Chris Bonbright. Should I speak later, or do you
Yeah,
want me to go ahead?
that's a good idea.
Pardon me?
Yes, that'll be at the different stack.
Great. Okay. Thanks.
All right.
Chris Bonbright.
Okay. Dietrich Nelson. Dietrich Nelson. Jim Hyogon, I believe. Sandy Summer. Sarah Jane Schwartz. Good day, sir.
Hi, I'm Dietrich Nelson, and I'm Emergency Services Chair for 2 Hollywood organizations, and I'm speaking here today as a homeowner in Hollywood. There have been many projects that have been approved by this committee and the City Council, and in each case, they've stated that there is no need for additional police or fire. Presently, emergency services are at capacity dealing with existing residents, businesses, tourists, and events in Hollywood. The proposed building of these massive twin towers at the iconic location of the Hollywood sign has the potential to generate a multitude of terrorism threats. LAPD and LAFD cannot possibly defend the buildings if they soar to these proportional heights and increased density. Who will pay for these services? Thank you.
Thank you, sir.
Thank you. My name is Jim Gagan. My wife and I have lived in Whitley Heights for 26 years. I'm a traffic chair for the Hollywood Hills West Neighborhood Council, which has voted against the Millennium Plan, and I also represent my stakeholders who have emailed me about this. I've invited myself to 7 Millennium pitch sessions in neighborhoods about this where they've gotten residents' reaction to it. And I can tell you what the reaction was. Every one of them was terrible, just absolutely terrible. And all I've ever seen is 58-story buildings. Today we have a buffet. There's a buffet of buildings. I don't know what they're going to build. We got a 35, we got a 44, we got a 58. Nobody knows what they're going to build. It's going to be a surprise. I've given 2 years of my life to this thing. I still don't know what the hell you guys want to build. New York City has 24 subway lines feeding Manhattan. We have one. We also have Penn Station, Grand Central Station, the PATH trains, and 5 ferries.
Thank you, sir. Thank you very much. Next speaker.
Hello, I'm Sarah Jane Schwartz, former president and current board member of the Hollywoodland Homeowners Association and a member of CURD. I am urging you today to make this a true hearing, to listen to the voices of the dozens of HOAs and neighborhood councils that have already voted against this project in its current form, to the voices of dozens of Hollywood residents that are here today at their own expense, trying to protect their lives and their largest investment, their homes, from a dangerous project that threatens both. And to the chorus of voices that will surely rise in the future if this project is allowed to complete its steamroll through the city. They will ask, how did something unprecedented that was so obviously inappropriate, too big and too dangerous get built? Why didn't anyone try to stop it? Didn't anyone see? Well, today, here, we can see, and we're asking you to listen.
Thank you, ma'am.
Good afternoon. My name is Sandy Summer, and to quote Lou Nadorf, the architect of the Capitol Records building, he says, "This does not mean that you pander to the needs of the developer. You need to understand the economic drivers of a project. There are the developer's needs and wishes, the residents' needs and wishes, and the community's needs and wishes. I think we have to have faith there is an overlap, a richer solution that responds fully to all people's needs. There are no community issues in these skyscrapers as we have seen the plan. I want to hold out for a richer solution that does address the needs of the community, because this is who we are. This is our aesthetic. We are Los Angeles, we are Hollywood, and we love this place. And this is what we enjoy every day, and every tourist comes to take a picture of this. This is our Hollywood. This has not gotten a good response from anybody. It doesn't make you feel good. And you guys are my protectors.
Thank you, ma'am. Thank you. Come on up, please. I'm assuming we called your name.
I'm Barbara Whitkin,
Yes.
and I'm here to ask, what are the benefits to the community? So far, I have not heard of one benefit to this community, only a deterrent. Thank you very much.
Thank you. Wow. That was short and sweet. Ann Gilgan, Ann and Stacy Sillins. And this will take up our 20 minutes.
Good afternoon, gentlemen. I'm Ann Gagan. I'm part of Communities United for Reasonable Development, and I'm a Whitley Heights representative and a resident of Whitley Heights for about 25 years. The project entitlements based upon the unlawfully adopted Hollywood Community Plan update are further subject to nullification. The project has been approved based upon the Hollywood Community Plan update, which is currently subject to litigation that may overturn the City Council's adoption of the new community plan and its associated zoning. The project has not been conditioned on the possibility that the underlying zoning will be placed back to zoning that is much less dense and used and approved in the letters of determination. The flaw is fatal to the density approved of the project. The Millennium developer can have no vested interest in the project density sought. Should the Hollywood Community Plan be overturned in the current pending litigation, you need to wait for the outcome of that litigation. You need to stop this project now. You all passed the Hollywood Community Plan after your council told you there were problems with it. You passed it to City Council with no recommendation, and Eric Garcetti got it passed, so you know what we are.
Thank you, ma'am. Thank you very much. Good afternoon.
Good afternoon. My name is Stacy Sillins, and I represent over 500 homes, Upper Nichols Canyon Neighborhood Association. And I'll keep it short and sweet because everybody's speaking so eloquently today, and I don't really have anything new to add except we agree with everything. Thank you for your time, and please consider everything that we're saying.
Thank you, ma'am. Okay. Those who are opposed, please stand. Those that speak and submit a card, please stand. We make sure you're recognized. Those that are opposed, please stand. Okay. These are the opposed, so your cards will go on record as opposed. We finished our 20 minutes. Now we'll go into the support. Thank you very much. Okay, now for supporting the project, the next 20 minutes is now 4:40. Chris Bonbright, LaRon Gubler, Callie Ray Cole, Alfredo Hernandez, and Giovanni Flores. Good day, sir.
Good afternoon, honorable council members. My name is Chris Bonbright. I am a longtime Hollywood commercial real estate broker, commercial and residential property owner, and community activist. As a stakeholder and someone who is passionate about Hollywood, I want to begin by saying how much I and countless other residents, community members, and stakeholders appreciate the fact that this developer has chosen our community to make this level of investment. It is a testament to what we, the Hollywood community, has accomplished over the last 20 years that we've attracted to this level of investment. Secondly, I want to talk for a moment about the concept of height. Some people seem to believe there's something inherently wrong about tall buildings. I believe the opposite is true. I actually love tall buildings. If I'm standing on a balcony at the Broadway Hollywood building or on a friend's balcony in the Hollywood Hills, I want to look out and be inspired. Tall buildings do that.
Thank you, sir. And please, the audience, let's respect each speaker.
Thank you very much.
Thank you. Let's respect each speaker. I believe while you were making your statements, there was a certain amount of decorum here. We would appreciate the same courtesy. Next speaker.
Hello, I'm LaRon Gubler, President and CEO of the Hollywood Chamber of Commerce. The Chamber supports Millennium Hollywood. There are currently numerous projects in the pipeline in Hollywood, but this is not just another project. This is, because of its location, the signature project that will define the Hollywood of the 21st century. It represents the very best of good urban planning, which LA needs. And so I ask, if we truly want to change the paradigm in LA, isn't it time we started doing it? Isn't it time when it comes to design that we try to do things a little more daring? If you can't build something truly exciting in Hollywood, then where can you build it? This is a visionary project that makes a statement that Hollywood is back and that our best days are ahead of us. It deserves your support. Thank you.
Thank you.
Good afternoon, Plum Committee members. My name is Alfredo Hernandez, and I'm a 32-year resident of Hollywood. And I ask that you support the Millennium Hollywood project. As a founding board member of the Friends of the Hollywood Central Park and now its first employee, I believe the Quimby fees generated by this project will be vital in building our park, which will create 44 acres of park space in Hollywood. In addition, Millennium will activate a dead zone only a mere block away from the historic Hollywood and Vine intersection, while preserving the historic Capitol Records building at the same time. Thank you.
Thank you.
Good afternoon. My name is Giovanni Flores, and I'd like to thank you for letting me speak today. I was born and raised in Hollywood, and I have seen many changes come to my community. I support the Millennium Hollywood project because it brings a modern streetscape that appeals to young people like myself and my generation. Transit-oriented development like this will one day allow me to live in a free life city without having to be on the cars, and I could always be on the train every day. Thank you for your time.
Thank you, sir. Kelly Ray Cole, are you here? Nicole Suninian? I always butcher your name, don't I? Jeffrey Williams, Elliot Johnson, Jorge Cubralejo. Hi.
Good afternoon, Nicole Shahanian. I'm a board member of the Friends of the Hollywood Central Park, and I'm here to express my support of this project. I am really pleased with the developers' commitment to green space and their efforts to make Hollywood more walkable. They've already, in fact, started doing things for the community around this, including a bike and movie and other things that really show the transit-orientedness of the site. And as a member of the park, I really would hope that we can allocate all of the Quimby funds from this project to the park. Thank you.
Thank you, ma'am. Jeffrey Williams, Elliot Johnson, Jorge Cavallejo, Scott Campbell, and...
Gentlemen, I'm Elliot Johnson. I've lived in Hollywood Heights, for 33 years. I checked the wrong box. I'm not opposed to development. I am opposed to the height, as I understand the Millennium Project. So I am standing here and I'm asking the developer, bring it down a notch. Make it nice, make it habitable. Thank you very much.
Thank you, sir. Next speaker.
Thank you for the opportunity, Councilman. My name is Scott Campbell. I'm president of Central Hollywood Neighborhood Council, which is just south of this project, south of Hollywood Boulevard. We've been involved with this project for a number of years now, getting presentations over and over again. And earlier this year, we did vote to support this project at its presented height of up to 585 feet. We feel that transit-oriented development is the right thing for this area of Hollywood along Vine Street. And if we're going to have height, this is the place to put it. So I'd like you to consider that there are a lot of people opposed to this project, but there are a lot of people who are unable to come out who are in support of this project as well. Thank you.
Thank you. Jeffrey Williams, are you here? Jorge Cavallejo, Tal Gabelson, Stephen Woodward, John Tronson. Either you don't want to speak or you're gone, one or the other. Charles Shulman, Brandon Mason. Come on up. Give us your name.
Tate Gabrielson.
Okay.
As a young professional working and living in Hollywood, I am here in support of the Millennium Project because of the benefits that I believe come with allowing for, and preparing for density. I plan on being here for a good part of my adult life and would like to be able to look forward to Hollywood's enrichment of employment opportunities, public transportation, and a ground-up revitalization that only substantial stimulation like this can promote. Developmental growth in our community is inevitable, and streamlining such project allows for effective allocation of the economic benefits to follow. Thank you for your time.
Thank you, sir. Next speaker, come on up.
Hi, my name is John Tronson. I'd like to just share that I own a live-work loft in the Broadway lofts, and the Millennium Project will effectively be built directly in my line of sight for the Hollywood sign, and I can't wait to see it constructed. It's a wonderfully designed, beautiful project. I can't wait to see the businesses that are moving into the office space. I can't wait to meet the residents that are going to come in there and enjoy the amenities that go into the retail spaces. And I think in large part what's happened over the last 20 years in Hollywood is developers like Millennium have put a fortune into this community and really helped it turn into what it is today from what it was 20 years ago. And I'd like to see that progress continue. Thank you.
Thank you. Next speakers.
Good afternoon, Charles Shulman. Good afternoon, I'm Charles Shulman, a Hollywood neighbor, and I support the Millennium Hollywood Project. The developers have worked with the community for more than 6 years and have created a community benefits package which enhances the quality of life for all stakeholders. The open courtyards in the Millennium Hollywood will be lively, enriching, and will be a place for the developers to take steps to ensure the space will be enlivened on a regular basis, with money set aside to pay for the programming of arts and activities. Moreover, those events will be community-oriented because the events will be held with the help from the Hollywood Arts Council and the Hollywood Entertainment District. Thank you.
Thank you. Next speaker, please, come on up.
Good afternoon. My name is Brandon Mason. I am a Hollywood resident and unconditional supporter of the Hollywood Millennium Project. While I'm in agreement with everything that was said just before me, I want to point out something that was brought to my attention today at the Economic Summit. Between the years of 2001 and 2010, the Red Line has had an 80% increase in usage on daytime riders. And if everybody's talking about the amount of traffic that's going to be caused by this project, I mean, we need to look at the grand picture of where's the post-educational dream. Everybody wants to go to an urban densification or city that's full of urban densification, such as San Francisco, Chicago, New York, Boston. People like to walk. We're going green. This is a project that's going to let that happen. So let's have that post-educational dream become now Hollywood, where we can keep the future of tomorrow at home.
Thank you. Stephen Woodward, Ron Miller, Rodrigo Garcia, Piedmont Brown, Randy Meyer, Adrian Scott Fine, Victor de la Cruz. You're welcome to come to the microphone.
Good afternoon, Councilman. I'm Ron Miller, Executive Secretary of the Los Angeles Orange County Building Trades. And on behalf of the 140,000 men and women that work and live around the city of Los Angeles and Orange County, and on behalf of the County Federation of Labor, they wanted to be here but they couldn't, and the hundreds of thousands of people they represent, we are in full support of this project. We've been working with the developer for over 6 years. This is a good project. It's good for the community. It's a transit-oriented development. It's going to help our members get rid of a car and be able to live around the Hollywood area, hop on the subway, and go to work and be part of the community more than they are. So let's move this along and get to building. Thank you.
Thank you, sir. Please, go ahead.
Good afternoon. Adrian Scott Fine with the Los Angeles Conservancy. The Conservancy has been primarily focused on the project development regulations that establish definitive standards and guidelines for new construction at the project site. Through our discussions with Millennium Partners, the Conservancy is confident now that we now have specific language in place that calls out and protects the significant view of Capitol records from the corner of Hollywood and Vine. Further, Millennium Partners has agreed to a 30-foot separation between the two-story historic Hollywood Playhouse. The Conservancy is in support of these precise safeguards that protect the view corridors of the historic Capitol Records building and provide adequate safe space between the new construction and the historic structures. Thank you.
Good afternoon. My name is Piedmont Brown. I'm the president of the Ironworkers Local 433 with thousands of hardworking members. I'm here on behalf of our members to support the Millennium Hollywood project. Right now we have members on the job in the Hollywood on the Sunset Boulevard building, the new Emerson College. There's a lot of growth today in Hollywood. That's because years ago we made the right decision to build the Red Line subway. Local 430 helped in that project. With the Red Line in place, we could build new developments without a terrible impact on traffic. Millennium Hollywood is a transit-oriented development. The aim is to get people out of their cars, to get them into the city, the urban experience. When we built the Red Line, people said no one would ride it. They said no one in Los Angeles would get out of their cars and get on their trains. Well, people do ride the subways. I'm living proof of that. I rode it for 4 years when I worked out in the fields. The ironworkers love to put up high-rise buildings, and the Millennium Hollywood project is a smart transit-oriented development. I hope for your support. Thank you.
Thank you. Good afternoon.
Good afternoon, council members. Victor de la Cruz with Manat, Phelps, and Phillips on behalf of AMDA College and Conservatory of the Performing Arts. AMDA's Hollywood campus, which is immediately adjacent to the Millennium Project site, has educated some of the world's most talented singers, dancers, and actors for years. With approximately 700 full-time students using the 8 buildings that comprise AMDA's campus each day, some of which share a property line or are across the street from Millennium, AMDA was initially very concerned about how construction would impact the school's operations. Today, we are very pleased to be here in full support of the project. Millennium has risen to the occasion by listening and working closely with us to ensure that AMDA will not only be able to operate, but thrive during construction. Those issues resolved, AMDA believes that students who come from all over the world to study at its campus deserve a neighborhood with great architecture, public spaces, and a mix of uses that will activate sidewalks and provide for a safe, vibrant environment. This project does that. We look forward to the new, vibrant environment that this transformative project will create not only for AMDA, but for all of Hollywood, and respectfully ask for your approval. Thank you.
Thank you. Mr. Garcia.
Good afternoon. I'm Rod Garcia. I represent the Hispanic Engineers Business Corporation. We're in support of the project. We believe it'd be economically beneficial to the community. We look forward to being it built.
Thank you for all your work, sir. Randy Myers, Scott Donahue, Terry Tilton, Ed Hunt, Aideen Foreman. Good afternoon, ma'am.
Hi there. My name is Randy Meyer. You called my name. Must have filled out the card wrong. I represent the Los Feliz Improvement Association. We represent 1,000 households in Los Feliz, and we have some serious concerns about the current scope of the Millennium Project. We do support the revitalization of Hollywood and the redevelopment of Hollywood, but currently we see some significant flaws. The outsized height of this project raises safety, practicality, and appropriateness questions. As a community of people who live, work, and drive through the development site, we're deeply concerned about the impact of the greatly increased traffic. I just want to say that we support the opposition of all those contiguous neighborhoods who have very clearly voiced their concerns today. And in the face of this, the Planning Committee seems to move in lockstep with its leader, who happens to be the architect of the project, a serious concern for us. We urge you to take a serious look at the project and balance community concerns with reasonable development. Thank you.
Thank you, ma'am. Sir?
I'm Edward Hunt, president of the Melrose Hill Neighborhood Association, a 35-year resident of Hollywood and a licensed California architect and landscape architect. This is a truly exciting, mixed-use, transit-oriented project that gives up an amazing one-third of the site for open space and pedestrian uses. I would rather see tall, slender towers that are part of the view than short, fat towers that block the view. We like the treatment of the iconic Capitol Records building. It's a wonderful piece of sculpture, and we urge you to approve the project. And I'm looking forward to being able to bike over from my house. Thank you.
Thank you.
I am Terry Tilton. I am a resident of Hollywood for 35 years, live on Hollywood Boulevard at that La Brea intersection. I'm also on the board of directors for Hollywood PAL, and I've been very involved in our community over the years I've lived in it. This is a tremendous project that needs to move forward. I came to our community when our streets were filled with prostitutes, with drugs, and to the point where we were afraid to get out on our streets. What we have now is amazing, and it's because of the revitalization. It's because of people like Phil Ahrens and the Millennium Project. Hollywood and Highland exist because somebody had a vision. Millennium has a vision for our community, and we need to be part of that. I do agree with all sides. One thing we do have mutually agreeable is passion for our Hollywood.
Thank you. Ma'am?
Good afternoon. My name is Aideen Foreman, and I'm the Executive Director of the Los Angeles Hospitality and Training Academy. On behalf of the HTA, we wish to express our strong support for the Millennium Hollywood project. Millennium Hollywood has joined in partnership with the HTA so we can ensure local residents are recruited and trained for high-quality jobs at this hotel. The Hospitality Training Academy is a nonprofit institution and a true labor with Unite Here Local 11 management partnership. It's a Taft-Hartley fund that provides benefits to both employers and the employees of the new hotel. We partner with educational institutions, nonprofits, and other groups to make sure that those who work in the hotels are well trained. Therefore, we support the project and for the process to move forward for final approval. Thank you for your consideration.
Thank you, ma'am. Okay, Rachel Torres, Priscilla Chang, Philip Alderstadt, please come on up, and Raul Munoz.
Good afternoon. My name is Rachel Torres. I'm a research analyst for Unite Here Local 11. We represent about 20,000 members, and we wish to express our strong support for the Millennium Hollywood project for a variety of reasons. Hollywood is fast becoming the epicenter of new and hotel and commercial development. In collaboration with the city, community, and local business, we have transformed the area from a community with poverty wages into a revitalized tourist destination with good living wage jobs that benefit the entire city. The Millennium Hollywood Project continues this strong precedent of responsible development from the Hollywood and Highland Project to other hotel developments. This project will receive no city dollars, nor is it on city land, yet thousands of good jobs will be produced for the construction and permanent employees. We want to express our strong support for the project and encourage the Planning and Land Use Management Committee to vote in favor of the project. Thank you.
Thank you.
Hi there, my name is Phil Alberstadt, and I'm a resident of Hollywood. I just wanted to say that I agree with a lot of the people that were up here before me. I believe that this development will be game-changing, transformational. It'll give a lot of benefits to our families. I think that a lot of the people that live in the Hollywood area are in support of this. They're not overly well represented, and I think that hopefully I'm speaking on the behalf of some of my neighbors and my friends that are in support of this, and I hope that you will look into this and make it move forward. Thank you.
Thank you. Next speaker.
My name is Raul Munoz, and I'm living in East Hollywood for the last 28 years. And I came to support Hollywood Millennium because I think this is a good investment to our community. Our community needs the jobs, traffic. We live in a city traffic, LA, and I think that's a good idea for our community. That's it. Thank you.
Thank you, sir. Mara Johnson. Priscilla Chang. Philip Alderstadt. Yes, please.
Good afternoon. My name is Maura Johnson. I'm the Housing Director of Hollywood Community Housing Corporation, and I'm here to speak in support of the Millennium Hollywood mixed-use development. Hollywood Housing appreciates all the outreach performed by the project owners, Millennium Partners, and Argent Ventures. We're aware that they have committed to have a local hire program which includes an apprenticeship training component, contribute funds toward the creation of 100 low-income housing units, which we hope will be located in Hollywood, and have a project labor agreement. These commitments to helping improve the lives of low-income working Angelenos are greatly appreciated, and we ask that you approve this project. Thank you.
Thank you, ma'am. That does take us to 20 minutes. Those who wrote cards in support, please stand. Wave your hands. That's a good, too. All right. So your cards will be submitted for the record. I appreciate your being here and your patience. So that does conclude. Oh, wait a minute. I've got general comment cards on this item. So let's go through those cards, then we should be done with public comment. We have Gary Handel. You already spoke. Tyrone Ross, I believe. Tyrone Ross. 3191 Berendo. Okay. Brittany Braun. Doug Haynes. Sir, come on up. Genevieve Yogan. And Sharon, I believe it's Short. Hello, sir. Please give us your name.
My name is Tyrone Roy. I have trouble speaking. The Constitution, I believe, starts with we the people. And with that in mind, I'd like to say, since I've been here listening to this meeting, you guys have talked about laws, codes, and ordinances and rules. But at the same time, you talked about preferences and modifications and redesigns, which lead to variances. What I want to say is it seems that you should give the public a chance to weigh in on this redevelopment for this area in a timely manner. And as you guys are not representative of the people, but as quasi-representative of people, you need to go with the majority as the Constitution says.
Thank you, sir.
You're all by yourself now. My name is Doug Haynes. I just wanted to bring up a few points that haven't been referenced before. One is that the EIR acknowledges that this project would trigger the need for a new elementary school and potentially a new middle school. And there's no funding for that through LUSD, no state funding for a new school. And when you provide for schools, you don't take commercial land, you take residential land. And as a community that's been through that process before, I don't want to see hundreds of people lose their homes so a developer can produce other people's homes. I also want to bring up that there's no acknowledgement by the planning department or by the EIR of the fact that there's a significant deviation from the requirements of the advisory agency for parking on this project. It's required to be 2.5 parking spaces per unit, and instead it's 1.5. And we had this in a similar case, Hollywood Gower, that we recently had through the courts and we won. And in that matter, it was acknowledged that you cannot deviate. There's been no acknowledgement in the agenda or anything. There's a Brown Act violation on this matter.
Thank you. Mr. Haynes.
Good afternoon. Helmi Heserick with the Los Angeles Housing Department. I'm not here to speak for or against the project, but rather to advise the committee on the agreement on affordable housing. The Housing Department approached the developer with a policy consideration to provide 20% of the units as affordable, and they responded with a very strong support for the policy. We started to discuss how best to implement the policy and identified some potential developments. Since then, those developments are already moving through the pipeline, but the developer has committed to provide the funding, the gap funding they would have provided for those projects to the council district, to the Housing Department Trust Fund in support of affordable housing near transit in the Council District 13.
These are off-site.
Off-site, but near transit. And we've been working with the council office, and this isn't a requirement. This is completely voluntary. They are not displacing anybody, so this is a purely voluntary commitment on behalf of the developer.
Thank you, ma'am.
Thank you.
Thank you. Okay.
I should have said it's $4.8 million, and that equates, from our analysis, to approximately 104 units,
Okay.
which is more than 20% of the total units that we've been advised they're proposing.
Okay. Brittany Braun, are you here? Brittany? Okay, last time. Genevieve Gilgan? Geoghan? Sharon, I believe it's Short or Shirt? Whitley Heights? Okay. Then that does cover public comment. I know. We went with 20 minutes, and those that I called came forward. Those that did not get to call, I asked you to stand to let you know that your cards were in for the record. I gave 20 minutes on each side. Okay. All right. That does include all the applicants, folks that made their cards. So let's go to the district office. And do we have the council representatives here? Okay, while we're waiting for them, I do have an announcement regarding this project. It's just been turned in. My understanding is that the applicant consents to rescheduling the hearing before the City Council to July 24. So the applicant also consents to an extension of time for City Council action on the above mentioned cases to July 31. So it is currently moved to July 24th. City Council hearing. So that's been continued. So let's take give me a 3-minute break, and I'll be right back. All right. I want to thank you for your cooperation. If you can please take a seat. Thank you for your patience. My colleagues in the room. Okay, that does constitute a quorum. So we do have one colleague in the room. All right. Is Mr. Englander nearby? Mitch? Okay. All right. For the sake of clarity, our CLA, Roberto, can you please give us the new time frame, what it means, just to be very clear, what the new time frame means based on the June 18th letter?
My understanding, Councilman, is that this issue is before the City Council on July the 24th, and with a final deadline of July 31st for the City Council to act.
Okay, so that's the window.
Yes, sir.
Okay, so I want to be very clear, in case folks did not understand what I was saying. I saw some confused looks out there. So, at this stage, if we can call the applicant to the microphone. In the presentation, there were several scenarios of different heights presented. For the record, could you tell us what is your preferred scenario? What would be the height that would be reviewed by the council once it leaves this committee?
Thank you, Councilmember Reyes. On behalf of the Millennium team, and after listening to the concerns of the community in consultation with the council office, and understanding that there are a number of concerns relative to the height of the project, we at this point would be willing to and accept a limitation of the height at the 39-35-foot project that was presented today.
39-35
stories.
Right.
That's the project.
So that goes from, what was the original?
The original had a height of up to 55 and 45 stories. Those heights are being reduced to 39-35. The exact language of a condition that I would propose would be that the project shall be limited to no more than 39 stories on the east side and no more than 35 stories on the west side.
Okay.
And that would be a condition that would be imposed upon the project as recommended by this body.
And how that would be the substance of this report when we do write the committee report to the full council. Okay, now my understanding is that there are some, when it comes to the transit demand management policy, can you elaborate on those?
We have presented a wide range of transit demand management plans. We have also listened to the concerns of the council office and would recommend that the ones that were adopted by the Citywide Planning Commission be augmented with the following: that the number of park and ride spaces be increased on the site, offered by the site, from 10 to 50, and that the developer institute a program whereby we would be acquiring transit passes for the workers and residents within the project, and we would commit to a fund of $500,000 over 10 years, $50,000 a year towards acquisition of those transit passes. What we believe is that we can work with the MTA. What we understand from the Metropolitan Transit Authority, from Metro, is that there are programs that we can initiate through board action that would allow us to buy, to supplement a 50% buy at up to about 400 passes, and that's our intention, to work with Metro and with the council office and the mayor-elect's office to try to achieve that number with that amount of money.
Okay. Okay.
Thank you very much.
Any questions from the applicant?
Just one final question. There was some comments made by some of the public speakers that we don't know what the project is. We don't know what the actual composition is, that we may be analyzing a project that has a certain amount of square feet, but the ultimate product, we're not aware of that. Is that an accurate assessment?
The project maintains, as was presented, a set of guidelines and standards that allow the project to be built in a variety of configurations and uses. That is true, but the regulations that are imposed are set to create, in effect, an over-regulation of the site, so that no matter at what height or what configuration it gets built at, that there are specific design standards, much like a very specific plan that gets adopted. Yes. So at the end of the day, what was the concern is that you could build a range from 55 stories to 5 stories. What we've just done by our action is limit the upper end of that to 39 stories on the east side and 35 stories on the west side, so that it could never go beyond that, and set it within those guidelines, and then the specific standards for open space and the like apply.
How about the mix of residential and commercial?
The intention of the project as applied has a mix of residential uses. If you note what we've applied, there's a project that was applied for entitlement that basically is represented by the larger project that you saw. That project is then, with the guidelines, allowed to be shifted. The uses within that are also shifted. We've now limited the upper end of how high it can go, and the uses can shift, but it can't, if there is any shift in uses, it can't create any more impacts than were studied, and therefore we've limited the number of impacts irrespective of the use to ensure that there are no additional traffic mitigations that are necessary, in fact that traffic is mitigated, and that the size and density of the project doesn't create any additional impact on infrastructure than provided in the EIR.
Great, thank you. And then I'm bad at math, so help me percentage-wise, you're reducing it in height. What percentage is that, would you say?
Nearly 30%.
Nearly 30% or so,
30%,
roughly? Okay.
Roughly 30%.
Okay, thank you.
Thank you.
Okay, Councilman Englander. We had a quorum all along. He was right there.
I'm used to sitting over there. They usually don't let me sit at the big boy tables.
It's okay. It's all right.
Yeah, thank you. I'm good.
Okay, all right. Okay, no questions there. Office of the District would like to come forward and give us your statement pertaining to this project.
Good afternoon. Marcel Porras, Planning and Economic Development Deputy for Councilmember Eric Garcetti and Mayor-elect Eric Garcetti. First, we would like to thank the community for the passion and committed participation both for and against the project. We've engaged in multiple communications with the developer and stakeholders over multiple months, even years. After reviewing this project and listening to the community, we made it clear to the applicant that we did not support this project at 55 stories. We are pleased that the applicant in turn listened as well. This proposal of 35 and 39 stories represents a shorter project with more open space and more traffic mitigations. We commend the applicant for their willingness to work with their neighbors. At this time, we believe it is appropriate to move this proposal forward to the full City Council in July to provide an opportunity for the newly elected council to review this better proposal. Thank you.
These are the July 24th date, correct?
Yes.
Okay. All right. So I think we've covered all our bases and all the different facets of this committee hearing. Roberto, could you suggest language that would incorporate the actions of this committee so we can move this forward to the full council?
Yes, Councilman. The first action would be to deny the appeals for items 4 and 5. Second action would be to incorporate the changes that Mr. Newman alluded to, which is a 30 stories limitation for the east side and a 35-story limitation for the west side. Mr. Newman also mentioned incorporating a transit plan. He would work with the MTA. That should be reflected in the committee report. Also, the technical amendments that the Planning Department has enumerated in its June 18th letter should be incorporated. And you also alluded to the fact that this matters in the City Council on July the 24th.
Mr. Newman, anything we should add?
39, 35. It was 39 on the east side, 35 on the west side.
Yes.
I thought you said 30, sorry.
No, no, 35.
See, just negotiate another 9 decrease. Okay, 39, 35. and we're going to get there. Thank you, Mr. Newman, for helping with the
I
committee.
just wanted to add for the record that to accommodate the reduced alternative two, that there might need to be some changes to the development regulations so that they're consistent with this now proposed project.
So these are the technical amendments.
Right, so they're in addition to those that were submitted today on behalf of the department.
Right, all the corrections. Okay.
To adopt the environmental conditions.
So those are the actions before us. Any comments or responses to those recommendations? I would move that we take the actions as specified by the CLA and all the added technical recommendations identified by the planning staff, including the changes by the representative of the development. Is there anything else that we should cover?
Apparently, there's a letter from the applicant that was submitted to the city clerk, council members. That also needs to be adopted.
Okay, and that's the extension of the date.
I believe so.
Is that right, Madam Clerk?
No.
No? Another letter, please specify.
Councilmember Jerry Newman, again, there was a letter that was submitted to you that had certain requested changes relative to the conditions of approval of the CPC, that to the extent, as staff said, that a reduced project alternative was required, that would need to be implemented, and that letter was submitted on...
Committee members, it's the letter that I referenced for your consideration in my remarks relative to the changes that were mentioned. So that's already part of the record and before your consideration.
So it aligns. It aligns all the changes.
It aligns all the changes.
Okay. All right. Are we ready? This covers everything? Right. So we will include a letter that specifically aligns with the lesser number of stories of 39 and 35. And so I believe that covers all the items?
Yes, sir.
Okay, so that being said, the committee approves. And that's a yes from both of my colleagues. Yes. And that's 3 yeses. That's the action of this committee. Okay. Anybody here for general public comment not on the agenda? Seeing none, this meeting is adjourned.